I want to go back a little bit point in time. In fact, in 1990, the United Nations passed a resolution which urged upon all member states to work towards a simple and efficient extradition regime. And that resolution was followed by what is called a model treaty on extradition. And in that model treaty, it sets out all the things that the UN urges all member states to do or not to do. Now, again, I've extracted the quote here. It says, and I think this is the most important point that a lot of people would concentrate on, respect human dignity and recalling the rights conferred upon every person involved in criminal proceedings as embodied in the Universal Declaration of Human Rights in the ICCPR. ICCPR, I think, is very familiar, that by the colonial government, not by the SAR government. And as you could imagine, because it was enacted, well, maybe I shouldn't say because, but the fact that it was enacted by the UK government means that it follows very closely to the model treaty that I have explained to you that was adopted by the United Nations. Now, I should therefore very quickly remind you of the various safeguards that is already inbuilt into the present law. Never mind about the amendment, just look at the existing law as it is. First of all, extradition can only apply to serious crimes, right? And these crimes are defined. They are defined in a schedule which do not include political crimes or any crimes to do with opinion, or I would like to think human rights. So, by definition, if we were to enact Article 23 tomorrow, and I hope it won't happen tomorrow or at least for a few years' time, even if we were to enact Article 23 legislation, those offenses will not be able, by definition, will not be able to find themselves into this law, because this law is not applicable to political offenses. The second qualification is that the conduct must be serious criminal conduct in Hong Kong, were it to occur here. So when I read the booksellers saying that he wanted to go to Taiwan, I think to myself, he must be very poorly advised, because he hasn't done anything, as far as I know, which could constitute a serious crime in Hong Kong, not to mention that what he was accused of doing has a very, very high level of political nature. So I don't quite understand why he thinks that he would be persecuted within Hong Kong, but he is, of course, entirely free to choose the place of his residence, and he now left us and go to Taiwan, and good luck to him. Now, the third point is that no matter how you describe the charge, it must not contain any element of political nature. The fourth element is that even if the charge itself doesn't indicate it has a political nature, the request must not be made for the purpose of prosecuting on account of race, religion, nationality, or political opinions. Fifth, even if the charge were free of political elements, and you can't say that the prosecution was in relation to race, religion, nationality, or political opinion, if the person involved might be prejudiced in his fair trial or in his punishment, and may be restricted in his defense by reason of his race, religion, nationality, political opinions, again, the law would not apply. What the law says is that the ordinance doesn't apply. If the ordinance doesn't apply, then there is no power, no legal power for anybody, let alone Carrie Lam, the administration, or the courts, to extradite him. And of course, the law says very clearly that the writ of habeas corpus is always available to anybody being requested to be transferred to a foreign jurisdiction. And of course, if you apply for a writ of habeas habeas corpus, it would be a separate full trial by the court as to whether or not the elements mentioned in the ordinance have been contravened. The sixth safeguard is that the offender must not be extradited to a third place. What does it mean? It means that if you were extradited to Macau, Macau then cannot extradite him to China, or to the mainland, and so on. How do you police this? Well, we police this by extracting a relevant and apposite guarantee or assurance from the requesting party. Seventh, the offender must not be visited with death penalty. And again, in the case of Taiwan, if they were to make a formal request tomorrow, assuming the amendment passed, the first thing the Hong Kong government would ask is an assurance that the death penalty is not applicable to this poor young man. Because as I understand it, in Taiwan, there is no differentiation between murder and manslaughter. And so, theoretically speaking, this young Hong Kong person, if he were transferred to Taiwan, may face the death penalty. But if there is no guarantee, again, the law doesn't apply. The offender must not be subject to torture, another inhumane treatment, or his dignity be harmed. And again, this goes to the question of guarantee and assurance from the requested party. In this respect, the court is mandated to receive evidence and must first decide if these safeguards are met. And I want to cite an example, which is called the Lord Advocate against Dean. It is a case involving a Scot killing somebody in Taiwan while drunk driving. And he claimed that if he were extradited to Taiwan, he would be treated unfairly by fellow inmates because he is a foreigner, he's killed a Taiwan person. And so Taiwan has to issue a lot of guarantees, and there was a long trial in the UK which eventually ended in the decision in 2017 where the Supreme Court says that he could be extradited. In fact, that decision is of highly persuasive authority in Hong Kong. What should be the basis of the extradition? Well, if a defendant claimed that he would not receive fair treatment, then the court has got to look into it. And as I've set out here, in fact, what has happened in the Taiwan case, but I see the time is catching up, so I'm not going to spend too much time on that. Again, I want to sum up with a quote, another quote from the UK report. It says here, states have increasingly recognized that effective extradition should operate on the basis of mutual trust and confidence, and not on suspicion and accusations. In fact, if you look at the UK experience, at the last count, UK has entered into bilateral agreement and has extradition arrangements with 108 countries. I said here 94. That, in fact, is wrong. It's not up to date. 108. The US has got 110. And the list is more or less the same. And it includes places like, and again, I mean no offense, Bangladesh, Bolivia, Cuba, Iraq, Kenya, Libya, Mexico, Nigeria, Uganda, Zambia, and so on. Some of this you might think has a worse human record than China. So why is it the UK government and the US government think it's all right to have extradition arrangement with these countries? Do they not care about UK citizens, US citizens? Well, that shows that a lot of people nowadays are looking at this topic from the wrong end of the telescope. They're asking, what is the human rights record of the requesting party? But that's the wrong end of the telescope. The UN says that it is the requested party, i.e. Hong Kong, which is important. You apply the same human rights standard, the same fair trial standards to everybody, to every country, be it United States, UK, Libya, Iraq, Kenya, no matter who. If you come to Hong Kong, we apply the same standard which is set out in the law. And unless we are satisfied that a fair trial can be had and this person will be fairly treated, the law doesn't apply. So why do we bicker among ourselves, quarrel, go out on a march, and say you're worried? If you say you're worried, effectively you're saying you don't trust our own judiciary. Well, I'm sorry. I'm very proud of our judiciary. I'm very proud of the legal profession in Hong Kong. I once spoke to an Australian consulate, I don't know whether he's here or not, and I asked him, do you believe in our judiciary? He said, of course we do. Our Chief Justice was sitting on your court. Yes, we have eminent judges from Canada, from Australia, from the UK, sitting in our Court of Final Appeal. So if you don't believe in our judiciary, are you saying you don't believe in your own judges? So I'm saying that I'm here to answer all questions, but I'm telling you that we should be looking at the right end of the telescope. We should be asking, are these safeguards sufficient? And enter into a meaningful debate about how, if we need be, to improve the safeguards that we have. Let's talk on that basis. Thank you.
Thank you very much. Please, Mr. Kwok.
Sorry.
No, it's good.
I hope I will be fine.
Well, good afternoon. Thank you. It's a privilege and honor to be here always at the FCC. Now, you know, if the Hong Kong government really takes the United Nations standards so seriously, it would really save us a lot of trouble in a lot of issues. But unfortunately, they don't. Now, first of all, I want to talk about the way in which the government has handled this legislative proposal. And then I'll go into analyzing the legislative proposal. Why do I want to talk about the manner in which it handled it? Because it is important for the Hong Kong people and the international community to look at what this government is trying to do and the way they're trying to do it. Now, I would like to quote from a speech made by a former chairman of the bar, given in 2001. Our dear Ronnie Tong gave this very speech at the opening of the legal year, in which he said, "The people of Hong Kong have a legitimate aspiration, even expectation, that the ideals of the grand concept of one country, two systems will be realized, and that their constitutional freedom and right will be guaranteed and protected. That rule of law will continue to prevail." Very nice words, Ronnie. It is the constitutional duty of the Hong Kong SAR government to fulfill such aspiration and expectation. Again, fine words, Ronnie. Where a constitutional issue which directly concerns the fundamental right or freedom of the people has risen, and I quote, "Nothing will divide or even polarize a society more than if the government is to adopt a defensive mentality in any rational debate. No man is infallible, and no government is beyond reproach." End quote. Fine words, Ronnie. Defensive mentality. Let's talk about defensive mentality. When 130,000 people took to the streets, including my mother, on Sunday, what did the government come out to say? Well, Ronnie said, well, it doesn't matter how many people took to the streets. It doesn't matter how many people are to protest. This government must soldier on, must carry on with these legislative amendments. The Chief Secretary said, oh, you know, people just don't understand. They're uninformed. You know, they don't know what they're doing. In 2003, when 500,000 people took to the streets, similar comments were made by the pro-establishment. It seems that people never learn. This defensive mentality is what this government has. And it's not good governance. And I'm sure Ronnie would agree with me, because he went on to say this in his speech. Rather, the role of a responsible government as a leader of the community it serves is to analyze and explain to the people the important constitutional or rule of law principles and values involved in order to stimulate a calm and rational debate in the resolution of the constitutional or rule of law issue concerned. Exactly. I can't put it better myself. Well, what did the government do in this legislative amendment? First of all, in February, they put a one paragraph in the 15-page legislative brief, one paragraph to say that they're going to do this. No explanation, no introduction, just one little paragraph buried in a document, hoping that no one would notice. Of course, we noticed, and we raised it. We raised hell. How come this issue suddenly came about this way? And then the Secretary for Security did a 1-month consultation, or was it 3 weeks? I can't remember. That was so low-key, there was no proper document, no proper consultation document explaining what they're trying to achieve, the different proposals that one would expect they to come up with, explaining the pros and cons of each proposal and what they're trying to achieve. No, nothing. This so-called consultation lasted 3 to 4 weeks with no proper documentation explaining what this consultation is about, and there's no report. Up to today, there's no report of what views that the government received in this consultation. Now, what happened to that responsible government that Ronnie was talking about in 2001? That they have a responsibility to explain to the people, especially over this issue when it concerns the rights and freedoms of the Hong Kong people. What happened to that responsible government, huh? If they are really responsible, they should do a proper consultation. As the British government, the US government, the Canadian government have pointed out, and other international members of the international community, if you're going to do this thing, you have to explain, because there are many complex issues involved. The people of Hong Kong deserves a proper explanation. None of that. So that's the attitude adopted by the Hong Kong government so far. And you can't blame the people, those who took to the streets on the 28th of April. You know, I don't think they don't understand it. They understand it. You know, they understand what is the government trying to do. They understand the implications to that. Of course, maybe they don't understand the legal niceties of the differences between the UK extradition regime and the Hong Kong one. But the Hong Kong people don't need to understand the legal niceties, because they understand the freedoms and their rights are being threatened. And they are entitled and should take to the streets. Now, let's talk about this amendment. Now, it's all started with this Taiwanese murder case, in which the government say that they want to resolve. Now, we fully support that. We fully different occasion how to amend our extradition regime in a wholesale or more fully considered way. But if you want to deal with the Taiwanese murder case, and when you have such a short time frame, there are ways in which you can make minor amendments to the existing regime, do an ad hoc arrangement with Taiwan. But no, they didn't. They don't want to do this. They want to do a wholesale change to the legislative proposal. But why? The Hong Kong Bar Association also pointed out you could confer jurisdiction on the Hong Kong courts so that the Hong Kong courts can deal with this Taiwanese case. Why don't you adopt that approach? Simple. It would receive the support of my colleagues in the Legislative Council and the understanding and appreciation of the Hong Kong community. There are ways to deal with this Taiwanese case. But no, you know, they choose not to do it in these ways, and they have to carry on with this major wholesale reform of our legislative proposal that has been tabled in LegCo. You know, this exception that we have in our laws, that we do not extradite people to other parts of mainland China, was not a mistake. It was not a loophole. It was deliberately put there in order to safeguard the rights and freedoms of the Hong Kong people. Ronnie talks about human rights. We're talking about people being sent to a legal system where, frankly, we do not, and people understand why, that we don't have trust in that legal system in mainland China. And if you look at what happened to people there, who were standing trial there, people get detained indefinitely without trial, forced confessions, torture in some cases. Trial is 1 day, not open to the press or even family members, no independent legal representation, and certainly no independent judiciary. Now, we want to talk about human rights, due process, and fair trial. We ought to be talking about those issues, rather than beating around the bush to say that, is it the case that you don't trust our judiciary? Of course we trust our judiciary, and there's no question that the Hong Kong judiciary will do its job and can be fully trusted. But there's only so much a judge can do when presented with evidence that the question that he has to ask is whether there is a prima facie case on the surface of the documents that has been presented. Now, our ordinance also doesn't have additional safeguards that in the UK, for example, the Extradition Act 2003, there is a specific provision that allows the judge to refuse extradition if he believes that the extradition would violate the European Convention of Human Rights, Section 21 of the Extradition Act. We don't have such safeguards in Hong Kong. Why doesn't the government put in additional safeguards, like Ronnie has said? And come to think about it, the actual proposal now actually removes legislative scrutiny. It allows the chief executive to decide on her own what to do on the extradition matter, remove legislative scrutiny that we have right now. It removes the court's function in authenticating supporting documents. So the courts have lesser of a power to scrutinize the process. And there's no increase of the power of the courts. As I said, like in the UK, they can refuse an extradition if they believe it violates the person's fair trial and due process. None of that. You can't give the burden on responsibility on the judiciary when it is really the duty of the government, the executive branch of government, to ensure that we do not enter into extradition agreement with places where there are no rule of law. Now, you mentioned there are, yes, countries that has entered into extradition agreement with China, Spain, Portugal, France. But note this one thing. These countries expressly stated in their extradition agreement with China that they do not extradite their own citizens to face trial in China. Why? Because they know very well they do not trust the rule of law or the legal system in China. And that is a matter of fact, a consensus held amongst many members of the international community. Now, very briefly, I want to talk about the Taiwanese situation. Now, the Taiwanese Mainland Affairs Department came out to say, the Mainland Affairs Authority, Lok Wai Wui, came out to say that they've noted what the chief executive has said, that there are many concerns regarding the human rights implications of these current legislative amendments. They say that they are not prepared to sign an extradition agreement on the assumption that it would be a accepting of the One China policy, and also that unless these human rights considerations and concerns are resolved, they are extremely hesitant in signing anything with the Hong Kong SAR government. So at the end of the day, we can't even resolve the Taiwanese murder case. Even if these legislative amendments are passed and the human rights issues are not concerned, the Taiwanese authorities are not going to sign an extradition agreement with Hong Kong. So how do you resolve that Taiwanese murder case? It doesn't. It doesn't achieve even what they say they want to achieve at the very beginning. So let's come back to trying to be sensible, or trying to be, really, if you want to resolve this issue, let's separate the Taiwanese murder case. Let's focus on that. We can get behind all the different parties in LegCo to support a one-off ad hoc arrangement to deal with this Taiwanese case, an arrangement which the Taiwanese authorities will accept and actually sign. Something can actually be achieved at the end of the day, rather than go about this wholly out of the blue, ill-thought-out, sudden legislative amendment with no proper consultation. It will only drive to divide the society even more. Now, Carrie Lam has said at the beginning of her term, saying that she wants to heal society, she wants to bring people together, she wants to heal divisions. Then stop this thing, Carrie. You are dividing society, you are damaging Hong Kong in unprecedented ways, and also to one country, two systems. I hope Ronnie will bring this message back to her next time when they have a meeting. Thank you very much.